Hi everyone. So today I want to talk to you about our new newsletter, which is going to be released today at 1 p.m. UK time. So be on the lookout for this. And it's focused on whether at the moment the current legal framework in the music industry forces artists to actually hand out songwriting credits to competitor musicians. So it's a quite an in-depth article, but at the same time it's quite funny. It's quite quirky because I have included all these basically music tracks to show you what I mean by giving you a definition of sampling, by giving you a definition of interpolation, and also by explaining to you, where there are some borderline cases in terms of copyright infringement, etc., and where also the current case law stands, in particular from a US law standpoint. Because most of these big stakes legal cases are actually trialed in California most of the time, and prominently the Ninth Circuit Court of Appeal of the state of California comes over and over and back over and over, having to take some decisions on all these cases. So in a nutshell, in relation to this topic, whether in the current music ecosystem artists have to hand out songwriting credits, the first point is actually to speak about the landmark case in relation to sampling, which was the O'Sullivan versus Jay Sharkey. I think the rapper was called Jay Sharkey, or B Sharkey, back in 1991. So O'Sullivan was an Irish performer, quite famous, I think, in the 70s and the 80s, and he released a song called Alone Again, Naturally, and Jay Sharkey, in a very cheeky way, also released a song called Alone Again, and then it goes, Alone Again, Naturally. So O'Sullivan, who had not been contacted prior to the release of Beat Sharkey's track Alone Again, filed a lawsuit in the US against B Sharkey because he deemed that he alleged that B Sharkey had actually lifted, i.e. Infringed on his copyright in relation to, well, first the lyrics, Alone Again, Naturally, and also on some portions of the music composition, which are repeated in a loop in the Jay Sharkey Alone Again track. And actually the US court basically gave reason to O'Sullivan, and decided that from now on, samplers, so songwriters who make common use of sampling and samples in their new songs, need to obtain the prior consent from the original songwriter and also owner of the master recording of a sample that they want to use and to insert in their track. So let me just take a step back here and explain to you the difference between copyright on music composition and copyright on the masters. In music law, there are two types of copyright. There's the copyright which belongs to the songwriters, the lyricists, and their publishers, which is on the musical composition and the lyrics. And that is called usually the publishing rights. The second copyright is the copyright which is allocated to the owner of a sound recording. So when you record the track, right, it creates a sound recording, and so there's copyright on that, and the copyright on the sound recording usually belongs to the performer, obviously, who performs the track, as well as the label, because the label just produced everything. And so that is called the master copyright, the copyright on the masters. So when you sample, you use an actual existing sound recording, which is based on some lyrics and some musical composition created by some lyricists as well as some songwriters. So you need to clear 2 licenses. You need to obtain 2 licenses from the owners of the publishing copyright as well as the owners from the master copyright. So obviously when this landmark ruling was handed down back in 1991 on the O'Sullivan v. Sharkey case, this created like a massive, tide of surprise, especially in the rap and hip hop community, because these artists use sampling a lot. They use a lot of samples in their tracks, but not only. But for example, there's quite a lot of sampling also being used in pop or electronic music, but in particular, hip hop and rap musicians do use quite a lot of samples. And after the 1991 ruling, it became just too expensive most of the time to actually obtain some pre-clearance, some licenses for both the songwriting as well as the masters. So some artists like Dr. Dre, for example, started using less and less samples, just focusing their new musical compositions on just 1 or 2 choice samples, the best samples, and then working on it with that, because sometimes they were confronted to songwriters, right owners, who were asking them for even sometimes 100% of the credit. So when you say 100% of the credit, it means you guys who are creating my this new song using my sample, you're not going to get any publishing rights. I'm going to get 100%. And some very prominent artists like Bob Dylan and the Rolling Stones in particular are famous for doing this. Yeah, they're taking either 100%, or in the case of Bob Dylan, I think he negotiated 50% of the publishing rights, which is a lot. But then they're like, yeah, but you're using the prestige, of Bob Dylan, you're using the prestige of Rolling Stones, so your song is going to become a hit thanks to that. So you should thank us and not the other way around. So basically, coming back to Dr. Dre, what he did as well is that he started doing a lot of interpolation. So what is interpolation? It's the use of only the sound recording and lyrics of a particular extract, a particular sample, a particular extract, but not the sound recording. So I repeat, it's the use of the lyrics and the did I say the song recording? I said incorrectly. The use of the lyrics and the musical composition of a particular song, but not the sound recording. So if you do that, if you do interpolation, therefore you only have to secure a license with for the publishing rights, i.e. with the songwriters and the publishers. So that's less expensive because you don't have to ask a license to the owners of a master recording. And so interpolation became quite a thing after the 1991 landmark ruling I just mentioned. And for example, Eminem in his famous track, Sun Shady, he actually used an interpolation from another track I mean, do look up my article, and you will be able to click on the link and see exactly what I mean. It's pretty plain and clear when you read the article. But Eminem, who actually was produced by Dr. Dre, used in one of his biggest and earliest hits this technique of interpolation to a lot of success. So things were, to a degree, pretty clear on how it used to work in the music clearance business up to the Bloodline case. Oh, and by the way, there were some hurdles along the way. For example, the Bittersweet Symphony case, which is the Verve against the Rolling Stones. So what happened there? In 1993, Richard Ashcroft, a successful frontman of the Verve and as well as songwriter and singer, created the Bittersweet Symphony, the aptly named Bittersweet Symphony, in which he actually sampled an extract from a very famous hit of the Rolling Stones. It was basically a reprise of his hit from the Rolling Stones by the Andrew Loose Orchestra or something. So it goes dun, 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 the Bittersweet Symphony. But anyway, so there is a famous sample from the Rolling Stones in there, and some other samples had been put into the Bittersweet Symphony, but it didn't really work out. So they actually went back to the original idea with this sample from the Rolling Stones interpretation by Andrew Loose. And what happened is that the record on which the Bittersweet Symphony had to be released was about to come out, right? So and then they think, by the way, we need to actually clear a license with the Stones, with Keith Richards and Mick Jagger, who are the songwriters for this particular big hit that they lifted in the Bittersweet Symphony. And so, due to timing issues and them not, the Verve's management not really anticipating anything, they went at the 11th hour to the Stones, and in particular to the Stones manager, Alan Klein, I think, at the time, and the guy just did them over big time. Why? Because he actually asked on behalf of Jagger and Richards 100% of the publishing rights. So up until 2 years ago, I think 2019, Richard Ashcroft had zero publishing royalties in relation to his massive success, Bittersweet Symphony. 2 years ago, what happened is that Richards and Jagger finally came to their senses, at last, realizing that what they did was just fucked up, and they actually transferred the ownership of the songwriting back to Richard Ashcroft, allegedly, as set out in a lot of articles. So anyway, as I was saying, there were quite a lot of hurdles along the road, as I just explained with this Bittersweet Symphony case, which was indeed very bitter for Mr. Ashcroft. But I mean, all in all, things were clear. You had to actually do pre-clearance before issuing the track if you were using some sampling with the owners of the musical composition and lyrics, as well as the owners of the sound recordings if you were using a sample, and with the owners of the songwriting and of the musical composition and the lyrics in case you were using interpolation. And things actually changed dramatically with a Bloodline case, which was concluded in 2018, if I remember well. So what happened there? As we all know, because it's still very recent in our memory, Pharrell Williams, Robin Thicke and T.I. released back in 2000, I think it was 14, Bloodlines, which was a massive success. And immediately the estate and family of Marvin Gaye, the songwriter on Got to Give It Up, started making some public allegations that the song Bloodlines infringed on the copyright of the Marvin Gaye estate in relation to Got to Give It Up, the song Got to Give It Up. So, annoyed by these claims, which seemed pretty unsubstantiated at the time, because perhaps Bloodlines has got a similar, a similar feel, a similar groove, a similar, feel to Got to Give It Up, but no musical composition, no lyrics are the same at all. Even the sound recording sounds different. So it seemed pretty unsubstantiated, these claims that there was any copyright infringement in this particular situation. So the three songwriters of Bloodlines, Pharrell Williams, Robin Thicke and T.I., the rapper, actually filed a lawsuit, again in California, in order to obtain a preliminary judgment which confirmed that there was no infringement. Unfortunately for them, the court and the judge in particular found for the defendants, so the Marvin Gaye family, and said that the defendants had provided enough elements evidencing that there was indeed some potential infringement of copyright in this matter. So on this, and since also the Gaye family filed some counterclaims, the case proceeded to trial, and the jury handed down its verdict, by which it actually found Pharrell Williams and Robin Thicke, not T.I., those two ones, songwriters only, Thicke and Williams, liable for infringement. So infringement of a groove, of a feel. This is just like, so it's usually you say that copyright is the protection of tangible output from creativity. It's not, copyright is not the protection of an idea. But in this particular case, it's extremely borderline, as you can see. I mean, I can say there's copyright on a groove, on a feel. It's just unbelievable. So anyway, the jury verdict found for the Gaye family and awarded them $7.3 million of damages and profits, which is massive in view of this case. And of course, the three songwriters for Bloodlines appealed. And in appeal, the damages were reduced to $5.3 million, but still, the jury verdict was actually affirmed by the Ninth Circuit Court of Appeal of California. And that's that, really. And so in 2018, the case was finalized, and Thicke and Williams had to pay $5.3 million to the Gaye estate, which actually sued Pharrell Williams for, I think, perjury or something, but that failed. It was rejected by the judge. Found that they couldn't bring any appropriate evidence of Williams' of perjury in court, and that was that. But this particular case, this particular ruling, Bloodlines, really sent a shockwave through the music industry, because then it meant that everybody could come at you and say, oh, by the way, your new track here, which is a hit, well, it's actually, a copy of the groove and the feel in my song from like the 1970s or something. And this is happening. This is what is happening at the moment. That every time that there is, a song which becomes a hit, you got potentially a raft of competitors, performers, songwriters knocking at the door and saying, hey, hand out a credit here because you copied my groove, you copied my feel. And so, I mean, of course, in these cases, which are called fair use cases, okay, so fair use as in, am I using this particular extract, this particular sample in fair use? Or so these cases, so this is fair use is a concept under common law, and in the US, it's pretty much it's used quite a lot in these music litigation cases. And so on these fair use cases, they are decided on a case-by-case basis. Okay, so there's no the outcome is not known at the beginning. It depends on the evidence which is shown during the trial, during the trial. It depends on the testimony. Testimonies given during the court hearings. So that's why it's called case-by-case basis. Yes, and there are two big lawsuits which came after the Bloodline case, which show that it's not basically a free for all. Like, it's not now that the new legal framework in the music industry is not anyone can come at you and claim a music credit. These two cases I'm going to talk about just basically tone down the effect of the Bloodline cases. And so these are the Katy Perry versus Page versus Katy Perry et al. Case, which relates to some allegations of copyright infringement of the song Dark Horse, which was released by Katy Perry in the a few years ago, around 2015-16, and there is an ostinato. So that's an ostinato. Okay, it's like a musical term which has been going on, for ages, since the Renaissance, really, even probably before. And so this is used throughout the track in Dark Horse as a bass, really, so it comes back and then back and in a loop. And there's a sort of Christian band called Flame, which approached Perry and the team and said, hey, you lifted that ostinato from actually our track, I can't remember the name of the track, which basically had 300 views on SoundCloud before they filed some summons against Perry. So Perry said that to her that she had never heard that they track, obviously, since it only had 300 views and only 300 clicks on SoundCloud. And so they sued Flame, this Christian group. But again, the courts in California looked at this case, and they decided that the two-part test showed that there were basically the Flame couldn't show that Perry had access to their music, firstly, and also that this particular ostinato had enough originality to be deemed to be protected by copyright. Why? Because it's been, as I said, used by songwriters and musical composers throughout the ages for hundreds of years and centuries. So on the back of that, even though the jury verdict found for the claimants, for Sage and for the group Flame, for the band Flame, the judge who looked into the case after the jury verdict, decided that no penalty, no damages were due by Perry and the team to Flame, because the claimants couldn't prove the originality of this ostinato being protected by copyright, so it was not protected by copyright, and also because the defendants did not have access to their music before the lawsuit. So that case on Dark Horse just toned down the message projected out there by the Bloodline case. And then there was the Stairway to Heaven case, whereby the estate of what was the name of this guy? Can't remember. So the estate of a guy who had wrote a song called Taurus, and they had opened actually for for the band Led Zeppelin back in the 70s, this particular band. And so the case was basically that the song from this band was Taurus, had been infringed by Jimmy Page and Robert Plant, the songwriters for Led Zeppelin, in the very famous track Stairway to Heaven. So it's basically the ta-na-na-na-na-na-na. So it's, you know, and listen to those two tracks. There are actually some URL links to those two tracks on YouTube in my article, which is going to be, as I said, released by way of newsletter and social media this afternoon. And yeah, and so again, same outcome than in Dark Horse. The US court, which had been asked to look at this matter, decided against the claimant, finding that they didn't have any substantial evidence showing that there was some real similarities between the particular extract of a track from the Taurus